This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. Vax mandates. There's a number of legal questions people have surrounding the vax mandates. One category is with respect to the emergency temporary standard that is going to be promulgated by OSHA and imposed on companies with more than 100 employees. But secondarily is even sans a federal mandate, a company's legal standing to impose vaccine mandates on their employees, and also as it pertains to whether or not to grant religious or medical accommodations. There's one approach that's been taken by Delta Airlines. We talked a bit ago, but let's refresh. Here's one approach companies could take, and one of the bigger companies in America, well, as all the airlines are. Delta Airlines' Ed Bastian explaining what Delta did prior to Biden's announcement of a mandate and where Delta is at present.
Well, the reason the mandate was put in by the president, I believe, was because they wanted to make sure companies had a plan to get their employees vaccinated. A month before the president came out with the mandate, we'd already announced our plan to get all of our people vaccinated. And the good news is the plan is working. At Delta today, we are 90% vaccinated, fully vaccinated across our entire company, and more vaccinations are coming in by the day. So I expect by the time we get to November next month, we're going to be at the 95% threshold. And when you consider there's going to be religious and some medical accommodations made that we're going to need to consider, by the time we're done, we'll be pretty close to fully vaccinated as a company without going through all the divisiveness of a mandate. We're proving that you can work collaboratively with your people, trusting your people to make the right decisions, respecting their decisions, and not, forcing them over the loss of their jobs.
And by the way, before we get to our next guest, some breaking news. This being reported by Fox, among others, that Colin Powell, former Secretary of State General Colin Powell, has passed away at the age of 84 at Walter Reed due to complications from COVID, according to his family.
Yeah.
So we'll talk more about that. Yeah. Mike Scott will have updates on that. But
and CNN saying he died from COVID complications. Fox News not yet confirming that. But yeah, he's dead at the age of 84.
So let's get to Joel Weber, Chicago area attorney and former executive at Whirlpool and General Electric, on the topic of employee vax mandates, as well as vax mandate bans, as Governor Abbott has instituted in Texas. Joel, thanks for joining us. Appreciate it.
Good morning, Dan and Amy.
So let's start with the OSHA, the federal coming down on private companies and the sorts of legal challenges that are being marshaled by the states, attorneys general for a number of states, and the kind of arguments that will be advanced in opposition to that mandate.
Right. You've already identified the fact that it's called an emergency temporary standard, which means it's not what we usually do when a federal regulation is being issued and approved. The question that the courts will face, and the lawsuits will come immediately upon its issuance. Right now, the regulation is pending in the Office of Management and Budget in the White House, and the guessing is it'll be issued later this week or next week. The question under the Administrative Procedure Act is, does it conform to that act? Does it give the public notice of the terms of the regulation? We don't know those terms. We don't know about medical or religious exemptions. And has the public had opportunity to make comments about it? This is a process that takes months, sometimes over a year. And so the question is, will the Biden administration's attempt to bypass that notice and comment right be validated? One of the big questions is going to be, in addition to whether they're just following the statute, one of the questions, as you've mentioned, is will it violate the U.S. Constitution? Obviously, we've got a free exercise clause, and the regulation cannot violate the Constitution. The courts will be answering that question. Second, might this emergency rule violate a federal statute? Notably, the 1964 Civil Rights Act, Title VII, protects employees from undue burdens on their religious practices. And so that'll be part of the picture. So bottom line is, if it does pass muster under the Administrative Procedure Act, a very big if, and if it does pass muster under the Free Exercise Clause of the Constitution and Title VII religious rights, then the Supremacy Clause of the Constitution will have it be in effect, and it will overturn things like Governor Abbott's state-based executive order in Texas. But that's where it is, and there are a lot of big ifs between now and the due process of law running its course.
And so if I'm a company with 100 or more employees, should I be holding my, if I'm not enthusiastic about this order, should I be holding my powder pending the outcome of some of this litigation?
I think the strict legal answer is I would hold my powder in the sense of watching the various circuit appellate courts in the country, which is where this kind of action will be challenged under the Administrative Procedure Act. Watch those courts. If you're in Chicago, watch the Seventh Circuit, et cetera, and see if the courts impose an injunction against enforcement of the regulation. That's the mechanical, that's the procedural step. And if you get that if the injunction is there, then you do not have to implement the rule. If the injunction is not there, then you've got a tough question as to whether you want to risk being in violation.
And with respect to these ETSs, these emergency temporary standards, I mean, there's case history here, and it's very rare that an emergency temporary standard is upheld by the courts without that due diligence, that comment period and other due diligence that you were describing. In point of fact, perhaps the most informative case for today is a 1974 case, Florida Peach Growers Association v. Department of Labor, where the ETS was struck down, and the Fifth Circuit Court explained there that this ETS gave the OSHA Act has given the Secretary of Labor extraordinary power, but the power should be delicately exercised and only in those in emergency situations which require it. And they suggested that this case involving farm workers and food growers didn't rise to the level of an emergency situation that required the exercise of this power. Is this all going to turn on whether or not this constitutes an emergency power that triggers a legitimate use, whether this is an emergency situation that triggers a legitimate use of this extraordinary power?
That's exactly what it's going to turn on, and this is why. This is a regulation if it goes into an effect. It's not a statute passed by Congress. Our representatives didn't have a chance to debate and vote on it, and the Administrative Procedure Act says the usual requirement is that the public gets to comment, and that the reason we allow you to skip the legislative process under the regulation framework is we're going to give this a good, thorough going over on issues like, in this case, medical exemptions or religious exemptions. So the question is, you're going to need a pretty well-defined emergency, and the Biden administration is going to have to convince the court, I say court singularly, these will come up in multiple suits in different circuit courts around the country, will have to make the case that there is something happening in mid-October 2021 that was not happening when Biden took the oath of office in January, when we all knew we were going to have COVID the COVID vaccine questions were going to have to be answered. And so that's going to be a very high bar, but it's exactly what you said. That's what it's going to turn on.
Almost going to be impossible, right? Because we're not in an emergency situation anymore. Amy, or is it how you define an emergency situation?
Precisely. I happen to agree with you that it's not an emergency because it's sufficient to basically, I waited 9 months to issue this rule, and now I'm going to tell you it's an emergency, right, and I don't have time for the public to be heard from. But the courts ultimately the Biden administration through the Justice Department will make that case, and ultimately their Solicitor General will make that case to the U.S. Supreme Court, because I expect the various circuit courts of appeal will have their own varying takes on this, and it won't be resolved until it gets to the U.S. Supreme Court. But Amy, that's going to be the problem. How do they convince the judiciary that there's an emergency under these circumstances?
Does Abbott's vax mandate ban, does that present an opportunity to see this get to the high court expeditiously?
Well, I think the expeditiously is going to come from the challenge to the Biden administration Occupational Safety and Health Administration regulation. Governor Abbott's executive order, let me just read to you the pertinent part. No entity in Texas can compel receipt of a COVID-19 vaccine by any individual, including an employee or a consumer, who objects, 1, for any reason of personal conscience, 2, based on a religious belief, or 3, for medical reasons, including prior recovery from COVID-19. I assume that refers to the antibodies. In this situation, basically, as you no doubt have reported, the Abbott has said that this applies to any Texas-based corporation, and in this context, if Abbott were to bring a lawsuit against in the circuit court there, the question would be if basically all roads lead to, is the OSHA regulation, does it pass due process standards? If it does, that just obliterates Abbott's executive order. If it doesn't, then Abbott's executive order stands, and it may be something you can attack on other grounds, but it won't be something that you can attack based on the OSHA rule prevailing.
Well, right. What about 10th? That's where I'm going. What about 10th Amendment grounds as the argument in favor of the vax mandate ban?
Great question. I think the 10th Amendment doesn't have teeth or operative effect in this situation. It's sort of the poor cousin of constitutional rights in the Bill of Rights context. And so while there are people around, I happen to be one of them, who believe that the framers meant that there are powers reserved to the states that this federal government can't trample on. The history under, from FDR to the Great Society to now, pretty much has rendered that an empty promise.
And
but I don't think it works.
So now let's dispense with the OSHA matter for a moment and just talk about, let's say there was no federal mandate, the OSHA the OSHA ETS gets overturned. So now you're back to companies deciding what they want to do. First question, just in terms of the how wide is the berth that employers have to impose these vax mandates that you're now seeing imposed under the cover of the federal mandate?
Well, the wideness of the berth is defined by the U.S. civil rights laws and state and local civil rights laws. So if it's a private company issuing the mandate, that a private actor, whether it's you or me as an individual or it's a private corporation, we're not constrained in our actions by the U.S. Constitution. We can't violate someone's free exercise rights, for instance, for religious exemptions. However, the Civil Rights Act of 1964, Title VII, gives civil rights to employees. And among those rights are the right to be free from undue burdens on their religious practice. And so if some private corporation were to impose such a mandate, privately in other words, the question would be, does that violate the Civil Rights Act of 1964? Have they given sufficient accommodation to the religious convictions of, say, a Roman Catholic who objects to the use of fetal tissue in the origins of these vaccines? Is that an undue burden? And that would end up in federal court.
So, as somebody who was an executive at a Fortune 500 company, you heard from Ed Bastian, the CEO of Delta Airlines. Does the approach that he's taking with respect to his employees, which seems to be, we would like people to get vaccinated, but if you have a religious or medical issue, then we're going to make accommodations. Is that just from an operational perspective, from a common sense perspective, from a organizational strength perspective? Is that the approach you'd be recommending?
Totally. I'm having flashbacks to. I've part of my career has been as a practicing lawyer. Part of it, as you mentioned, has been as an executive in a corporation or a couple of corporations, and there is, and I don't mean to beat up on my fellow lawyers, but some of us come roaring out of law school, and let's sue the guys, and let's have a fight, and I'm going to win, and a business person, and this sort of thing comes up in business all the time. And it's a fault line where the lawyers often are combative and want to assert their rights, and the business people, at least in my experience, were the cooler heads, and they'd say, if we're forced into a lawsuit situation, by all means we need to keep that in mind. But it'd be a heck of a lot better to have a reasonable exchange of views and come to a consensual result. And here what we're seeing is exactly what Ed Bastien of Delta did, which is, I suppose we could sue the government or we could sue our employees or fire them, but instead of a fist fight, let's act like adults.
And it seems like the same thing at Southwest Airlines, where Gary Kelly and the pilots union could probably work something out between them, since they're both positioned against such mandates, but you have the federal government intervening, and it at least from the perspective of the CEO there, it ties his hands.
Very much so, and I think ties his hands is the operative phrase, because Gary Kelly in particular, took pains to make it clear, I'm a CEO running a company. I'm going to have to obey the law, whatever the law ends up being. This mandate was not my idea. Since it's Southwest Airlines, it reminds me of the founder of Southwest Airlines, a man named Herb Kelleher, who was a lawyer by background. And he famously would avoid lawsuits. He once was threatened with a lawsuit, or the company, and he ended up proposing to the CEO of the party threatening the lawsuit, let's meet in an arena and arm wrestle, and the one who wins gets a contribution to our favorite charity. And that's what they did. But the cooler heads prevailed. But again, it's the old thing, if you're a child and you got a hammer, everything looks like a nail from the legal perspective.
He is Joel Weber, Chicago area attorney, former executive at Whirlpool and GE as well. Joel, thanks for joining us. Appreciate your insights.
Thank you so much, Dan and Amy.
Thank you. And he joined us on our turnkey.pro answer line.
Listen to podcasts of Dan and Amy from the AM 560 mobile app. Download it today at 560theanswer.com/mobile.
Is it time to have your sump pump checked? Hi, this is John with Basement Flood Protector. I'm a veteran and the owner. Since 1974, we've manufactured the most reliable and highest quality products and provided unmatched basement waterproofing and sump pump service to the Chicagoland area. Most problems with water in your basement have to do with your sump pump. Maybe it's old, doesn't work properly, or you just need more capacity. Most pumps should be replaced every 3 to 5 years. With our pumps, we recommend replacement every 7 to 10 years. At Basement Flood Protector, we offer a complete line of sump, ejector, and battery backup pumps. Do you really want the hassle and huge expense of restoration? Prevent it and contact us to schedule one of our knowledgeable technicians to assess your equipment. The Protector line of pumps are the most reliable on the market. Go to floodknot.com. That's floodknot.com. Basement Flood Protector. Integrity is our foundation. Floodknot.com.
If you're looking to purchase a new home or refinance your existing home, you need to call Team Hochberg, your trusted local lender. Tom, retired, Social Security income $30,000 with more than $2 million in retirement assets. Tom contacted 3 banks to refinance his Illinois home and purchase a second home in Florida. All 3 told him he didn't qualify, so he called Team Hochberg for a free consultation. Team Hochberg helped Tom refinance and purchase a second home with an asset depletion loan. Let's review. Before calling Team Hochberg, Tom was rejected by 3 banks. After calling Team Hochberg, Tom lowered his rate and monthly payment, refinancing his current home, and purchased a new home in Florida. Team Hochberg has helped thousands of AM 560 listeners use their retirement assets to refinance their existing homes and purchase new homes, like they helped Tom. But they can't help you if you don't call 855-56-DAVID or visit 56david.com. That number again is 855-563-2843, or visit 56david.com. Homesite Financial, Equal Housing Lender, NMLS 1124061.
Your health is a hot topic today, and the conversation always seems to lead back to your nutrition.